Bom dia, good morning, everyone. The Center of Fiscal Studies of FGV, da Fundação Getúlio Vargas, de São Paulo, organized since yesterday a series of events with the aim to clarify and to discuss with Brazilians and foreign experts, faculties, tax inspectors, practitioners, the newly signed and renegotiated conventions to avoid international taxation, among those with the one with Argentina and Uruguay, two panels that we are going to have this morning. And before passing through the stage to my colleague Michel to open the works of this morning, I have some information to you. All statements expressed by Fundação Getúlio Vargas employees or guests, our exposer and speakers here today, in our online events broadcasts exclusively represent their opinions and not necessarily the opinion of Fundação Getúlio Vargas. And this event was and is being recorded with the consent of our speakers and employees. Michel, the stage is with you. Please present our speakers of this morning. We are very anxious and excited to hear the impacts on the bilateral relation between Brazil and Argentina. Please, the word and the stage are with you.
Thank you, Paulo. I would like also to thank Professor Isaías Coelho and Professor Rico Desante for the kind invitation to host this panel today. And we will fly direct to Argentina to discuss the, already, it's not all that new, but the new protocol signed between Brazil and Argentina. And to do that, I would like to invite to this event the professors Ramon Tomazella and Professor Thomas Balzano. Ramon Tomazella is partner of Maurício Oliveira and Siqueira Campos Advogados, Doctor Use and Master of Law by the University of São Paulo, LLM International Tax Law by the Vienna University of Economics and Business, and also he just released his new book on the double economic taxation and the tax treaties. And I would like to invite Professor Thomas Balzano, who's partner of Pereira Godoy Advogados, Master of Law by the Universidad Torquato de Teja, and Professor of Tax Law at the School of the University of Buenos Aires. I'd like to thank you for accepting the invitation to be today with us and to discuss the tax treaty between Brazil and Argentina. And just to make some points here, I'd like to say that yesterday we'll have the pleasure to hear from representatives of the tax authorities from Brazil, some points, some concerns the Receita Federal do Brasil is having nowadays regarding tax treaties, mainly the abuse of treaty, mainly the map, and also the how we get to the policy we have today. And it's very important to discuss that. As you know, Brazil decided not to sign the MLI and renegotiate its treaties on a bilateral basis. So the first treaty is Argentina, and it's not a coincidence that we will start this panel today with you guys. And I expect it to be as exciting as a derby between Brazil and Argentina. So without ado, I'd like to invite Professor Ramon to represent Brazil during 25 minutes, Professor, because we have another panel after this one, to present the main issues, the main topics we have in practice regarding this treaty. Professor Ramon, the floor is yours.
Thank you, Michel. Good morning, everyone. First of all, I would like to thank Paulo Duarte for the invitation, and also to greet my colleagues, Michelle and Thomas. I'm happy to be here to talk about the new protocol signed between Brazil and Argentina and its impact on the cross-border transactions carried out between taxpayers in both contracting states. I'm gonna share my screen. I have a PPT presentation, and basically I will start off with a brief context of the new protocol, and then I'm gonna focus my attention on 5 relevant issues: cover taxes and capital taxes, prevention of treaty abuse and the PPT clause in the new protocol, taxation of technical services, methods for the avoidance of double taxation, and the enhancement of the mutual agreement procedure. So let's start with the context of the new protocol. As you all probably know, Brazil has not signed the MLI. It's one of the few countries of the inclusive framework that decide to renegotiate its tax treaties on bilateral basis. And there are a few reasons for that. First is that the MLI could generate lengthy discussions in the National Congress, thereby delaying its approval for years. Just to give an example, the tax treaty signed between Brazil and Russia took 13 years to be approved in the National Congress. So now imagine how long would it take to approve an instrument like the MLI that intend to modify several bilateral tax treaties in one single instrument. So probably a lot. The second reason is that Brazil would like to update other provisions of its tax treaty network. So we have tax treaties signed in the 60s and 70s that do not have the beneficial owner tax, that the non-discrimination provision does not have Article 24.4. The exchange of information does not include the major clause, according to which the contracting states can exchange information about tax not covered by the treaty. So Brazil take advantage of this opportunity to update its tax treaties network. And third, Brazil tax treaty network is relatively small, thus allowing the implementation of BEPS measures through bilateral negotiations. This is an interesting approach because countries can comply with the minimum standard of the BEPS project, but at the same time tailor their commitments to preserve their tax treaty policy in the long run. And as Michel mentioned, the new protocol signed with Argentina was the first treaty renegotiation carried out by Brazil, and it was signed in July 2017 and promulgated in August 2018. So it was approved in a relatively short period. That being said, let's move on to cover tax. The 2017 protocol now covers the presumptive minimum income tax and also added a new distributive rule dealing with taxes on capital. And in order to illustrate this issue, I'm going to use the Petrobras Energia case judged by the National Tax Court in Argentina. So Petrobras Energia had equity investments in 3 subsidiaries, one located in Bolivia, Empresa Boliviana de Refinación, and 2 other subsidiaries in Brazil, Inova and Eletricidade. And the question here is related to the levy of the presumptive minimum income tax, which was a tax charged on the total value of the assets of the Argentina company at 1% rate, and in general, it could be offset against the income tax. However, Petrobras reported losses in 2003, and then it was obliged to pay the presumptive minimum income tax. And in the calculation of the taxable basis of this presumptive minimum income tax, Petrobras excluded the value of the shares of these companies, the subsidiaries abroad, under the claim that income that could potentially be generated by those shares, such as dividends, interest, and capital gains, could only be taxed in the source country because at the time, in the original treaty, Argentina adopted the exemption method. And the original treaty was not applicable to tax on capital, and the presumptive minimum income tax did not exist at the time the treaty was signed. So the only way to apply the tax treaty to the presumptive minimum income tax was through the so-called extension clause, according to which the convention shall be applied to any identical or substantially similar tax imposed after the signature of the convention. However, the National Tax Court of Argentina concluded that the presumptive minimum income tax was not identical or substantially similar to an income tax, and then denied treaty benefits in that situation. And what changes with the new protocol is that now the presumptive minimum income tax is covered by the treaty, and we have a distributive rule dealing with the taxation of capital. But this would not necessarily change the outcome of the case, because now the Article 22(4) of the protocol of the new treaty allows cumulative taxation of income from shares, and Argentina no longer applies the exemption method. And Thomas also mentioned that Argentina repealed the presumptive minimum income tax, and then he can expand on that later on. The second issue that I would like to cover here is the prevention of treaty abuse. And the 2017 protocol has a new preamble, according to which contracting states intend to avoid double taxation without creating opportunities for non-taxation or reduced taxation. The new preamble is relevant because it may shed light on the interpretation of other provisions of the treaty, and it can help the countries to counter abusive tax planning structures. The 2017 protocol has also introduced the principal purpose test in the treaty, and it means that now tax authorities can deny treaty benefits when it's reasonable to conclude that one of the principal purposes of the transaction was obtaining that benefit. And this may be relevant in several tax planning structures I will explain later on. The 2017 protocol also introduced the minimum holding period of 365 days for dividends distribution. This is a rule that intends to counter dividend transfer transactions, and it also included the triangular PE provision, which deals with cases where profits are attributed to a PE in a third state whose profits are low taxed. The main issue here is related to the PPT clause, because it has been generating several debates among tax scholars here in Brazil. And the first issue is related to the low standard of proof, because tax authorities can deny treaty benefits when it's reasonable to conclude then that one of the main purpose of the transactions was the obtention of treaty benefits. So it's a very low standard of proof, and tax authorities are not required to provide clear and convincing evidence. The second issue related to the interaction between the PPT rule and domestic laws provisions, because Brazil does not have a guarding force, so it's not clear how the PPT rule will be applied to rule shopping structures, because in the absence of a guard, tax authorities cannot requalify the facts that give rise to the tax obligation. The third issue concerns the lack of a discretionary relief clause in the treaty. And according to the discretionary relief clause, the competent authority could be able to grant a different treaty benefits to the taxpayer in a tax treaty setting. And in my opinion, this is an interpretative provision, because as you can see here in the wording of the PPT clause, a benefit under this convention can be denied or shall not be granted. So if a benefit can be denied, it implies that a different benefit can be granted to the taxpayer. So in my opinion, the absence of the discretionary relief clause does not prevent the tax authorities to grant an alternative benefits to the taxpayer. And finally, we have the issue concerning the potential incompatibility of one of the principal purpose tests with the principle of the legal certainty enshrined in our federal constitution. And in order to illustrate how the PPT clause can be relevant in practice, I'm going to use the Ambev case as an example. It was judged by the Administrative Tax Appeal Council here in Brazil. And basically, Ambev had an equity participation in Honeck, a company incorporated in Uruguay, which had losses in 1999, 2000, and 2001. On December 22nd of 2002, Honeck went through a redomiciliation to Argentina, and in 2002, it earned profits. And then Ambev argued that the tax treaty signed between Brazil and Argentina would prevent the taxation of the profits earned by Honeck. The court accepted the redomiciliation from Uruguay to Argentina, but not the application of the treaties in relation to profits generated before the redomiciliation. So in the view of the court, only profits generated after December 22nd would be entitled to treaty benefits. So it's a kind of a pro rata application of the treaty. And the issue here is that it's a very controversial reasoning and very controversial decision in the absence of the PPT clause, because the taxation of foreign profits in Brazil occurs on December 31st of each calendar year. So at the time of the taxable event, Honeck was already a resident of Argentina and entitled to treaty benefits. So with a PPT clause in force, as one of the principal purpose of the redomiciliation was to have access to treaty benefits, because at the time Brazil didn't have a tax treaty with Uruguay, the tax authorities could then deny treaty benefits. So it shows how relevant the PPT can be in concrete cases. Moving on to the taxation of technical services, I'm not gonna spend too much here because I think the other panels will also address this issue. But I would like to point out that most tax treaties signed by Brazil have the extended concept of royalties, according to which technical services shall be taxed as royalties under Article 12 of the treaty. And only 5 tax treaties do not include such a provision, which are the ones signed with Austria, Finland, France, Japan, and Sweden. And I'm making reference to the original version because, as you know, these treaties are also under renegotiation. And the point here is that the scope and the reach of this extended concept of royalties is under litigation here in Brazil. Taxpayers usually argue that the extended concept of royalties only reaches technical services that are associated with the transfer of technology. So in practice, it would only reach ancillary services that it include in a mixed contract with encompasses the transfer of technology along with the provision of services. So this is a topic under litigation before the judicial courts. And in order to put an end to the discussion, the 2017 protocol introduced in the very treaty a definition of technical services. So according to this new provision, technical services are those that depend on specialized technical knowledge and that involve administrative assistance or the provision of consultancy services. So this definition, which is very similar to the one found in the Brazilian domestic law, shows that the taxation, that the extended concept of royalties does not depend on the transfer of technology. And in order to illustrate this debate in practice, I'm going to use as an example Mercado Livre case judged by the Federal Regional Court of the Third Region. So basically, Mercado Livre hired a company resident in Argentina to provide website development, support services, and maintenance assistance. And Mercado Livre argued that the remuneration paid could not fall under the extended concept of royalties because the agreement did not involve the transfer of technology. The court disagreed and held that Brazil could impose withhold income tax, but the case shows that the reach of the extended concept of royalties is open for interpretation due to the lack of a definition of technical services. So the inclusion of a definition in the treaty with Argentina may change the course of the current case law on the matter, because traditionally, the Superior Court of Justice has been applying Article 7 of the tax treaty for the remuneration from technical services without analyzing the extended concept of royalties. This approach has been adopted, for instance, in Copesul case and Iberdrola case. It's true that the case law started to change in 2020 in the judgment of Angecorp's case, because at this case, the Superior Court of Justice returned the case to the Federal Regional Court to analyze if the service agreement could fall under the extended concept of royalties. But the fact is that this is a current litigation in Brazil, and upon the introduction of a specific definition in the treaty that does not require the transfer of technology, it will be much more difficult for the taxpayers to argue that this remuneration should fall under Article 7 of the treaty. So in practice, it may put an end to this discussion. The next issue that I would like to cover very briefly are the methods for the avoidance of double taxation. And basically, there are 2 points that I would like to highlight. The first is that Brazil repealed the exemption for intercompany dividends. And the second is that Argentina replaced the exemption method for the credit method. So in practice, now both countries adopt the credit method for the avoidance of double taxation. And this amendment may be relevant, for instance, for the discussion involving the compatibility of Brazil's full imputation system with tax treaties. I'm gonna illustrate this debate using InterSament case judged by the Administrative Tax Appeal Council. So Camargo Correa held equity investments in 2 companies in Argentina, Loma Negra and Holds Total. And in addition to the argument that Brazil's full imputation system is incompatible with Article 7 of the treaties, Camargo Correa also argued that this taxation of foreign profits would be incompatible with the exemption method for intercompany dividends adopted in the treaty. And the court agreed with Camargo Correa and held that the exemption method in Article 23 of the treaty would rule out the application of the Brazil's full imputation system based on 3 main aspects. First, if dividends are exempted, there's no tax deferral, and as a consequence, there is no reason to apply a full imputation system or a CFC rule. Second, Brazil could not circumvent its treaty obligation of exempting intercompany dividends by taxing profits out of which the dividends are distributed. And third, the taxation of profits when dividends are exempt would frustrate the objective and purpose of the exemption method in the treaty. And what changes with the new protocol is that it will probably prevent this argument related to Article 23, because now both countries adopt the credit method. But on the other hand, the taxpayer may still argue that Article 7 prevents the taxation of profits of companies located in Argentina. And now it may have even more grounds to do so due to the absence of the saving clause, because as you know, Article 11 of the MLI has a saving clause according to which a tax treaty does not prevent a country to tax its own residents, and Brazil and Argentina have not adopted this rule in the new protocol, so they have now more grounds to invoke the application of Article 7. And finally, in relation to dispute resolution, there are 2 main aspects that I would like to highlight. The first is that taxpayers can submit the case to the competent authority of either contracting states. So now, for instance, a company in Brazil can start the mutual agreement procedure before the tax authorities of Argentina, that will then may put pressure on the tax authorities of Brazil to resolve the double taxation case. And second, the case must be presented within 3 years from the action resulting in taxation not in accordance with the treaty. In the previous treaty, it was only 2 years. And this may be relevant in practice for transfer pricing case because, as you know, Brazil does not adopt Article 9.2 in its tax treaty. So Brazil does not provide as a rule corresponding transfer pricing adjustment, but it agreed to submit transfer pricing cases to the mutual agreement procedure. So in practice, it may relevance because Brazil adopts as a rule for determining profit margins to transfer pricing control, and it may lead to cases of double taxations, and taxpayers can now use the mutual agreement procedure to try to solve those issues. I think that's it from my side. I would like to thank you all for the attention and hand it over to Professor Thomas.
Thank you, Ramon. Very interesting topics you brought to us, and also with many case law that exemplificates the main issues that we will probably have in the future. Now, I'd like to invite Professor Thomas Balzan to explain his concerns and how Argentinian taxpayers should concern and those changes. Thank you, Professor Thomas. The floor is yours. Thank you.
Thank you very much. Thank you, Ramon. Thank you, Pablo, for inviting me for this. Ramon, excellent explanation, 25 minutes. It's really difficult to explain all of that in such a short amount of time. First of all, I want to say that we will actually review this double tax treaty, or the treaty, from an Argentine perspective. We will not be repeating ourselves of the things that already Ramon explained, but maybe just to start, just a few comments about what Ramon was saying, just to clarify some of the points. Argentina has signed the MLI provisionally, and actually applying the MLI. You were saying about Brazil and its problems about applying the MLI. The MLI is really difficult to apply. You need to analyze it in each and every country, whether the clauses actually apply or not apply, and whether they would apply in the future. So when actually analyzing any corporate or tax structures, you need to analyze the past, the present, and more importantly, the future, and how this could actually change. And it is causing problems in order to try to choose the best possible corporate structure. The second point is, you were talking about this case in Argentina about the minimum presumed income tax, and as you said, it was repealed. So it's kind of an interesting case law, and in order to analyze that case law, you need to take into consideration that there's a local or an Argentine discussion whether this minimum presumed income tax was actually an income tax or a personal asset tax. And this discussion was actually held in court due to the fact that if it was a personal asset tax, it would have a double taxation over assets. So in that sense, they couldn't specifically say it was a personal asset tax, and they couldn't specifically say it was an income tax. So they need to say there's something in the middle. So in that sense, when you read those cases, you analyze that, and then you see how or why they say things in the way they do it. In Argentina, thinking about this LBs and thinking about the MLI and thinking about the new tax treaties, Argentina applies a substance over form rule from a long time ago. So in that sense, whenever we try to discuss treaty interpretations, it's actually limited to the rule we already apply, and we actually is a way in which we can interpret that rule. So in that sense, it's actually a benefit in some cases, because we have some way in which we can interpret the way in which we apply the substance over form rule in Argentina. Then I think you mentioned redomiciliation. That's a really I would say, important thing in Argentina. Argentina does not have a, let's say, an exit tax or an entry tax in Argentina for redomiciliation. So in that sense, we have seen companies from Argentina redomiciliate in Uruguay and vice versa. And there are some things that the law does not, let's say, rule, for instance. And one of the matters is what happens with the accrued income. Let's say that you had 11 months in Uruguay and then you come to Argentina and then you have the last month. So does Argentina tax the previous 12 months or only the last one? That's not clear, and it applies in a case-by-case basis. So in that sense, it's really interesting how this apply and how this work with the double tax treaties. And just going to the last comment before going to the presentation, technical services. That's something that Argentina argues and applies it different in every treaty. That is because of the definition of technical services and what with the application of the management fee allocation. We kind of use Section 7 a lot when analyzing international structures. And specifically administrative services compared to technical services and compared to registered know-how. And let's say that Argentina doesn't have a specific definition, so Section 7 and the analysis of Section 7 was really important. So in this case with Brazil, where administrative services are included in the definition, it kind of narrows the way in which you can actually interact between Brazil and Argentina in this sense. Now, going to specifically the treaty, we'll have to say that when this treaty was signed, there are some key features that you need to understand in Argentina. The first one, Argentina had only local source income levied by the income tax law, so it has not worldwide. So, for instance, the exemption rule had some sense there, but not now. Then, when this treaty was signed, Argentina almost had every treaty signed using at least as a beacon the OECD treaties or the OECD model, and this treaty kind of differed in many sections to the OECD, so it was kind of different for Argentina to sign this kind of treaty, exception for Bolivia, that we have the Andean Pact there, and it's an old one. And when the new treaty was signed, well, we kind of follow the OECD rule. We had worldwide income, so we have now worldwide income. And also, when this treaty was negotiated, Argentina negotiated other treaties. It changed other treaties, mainly because in the former government, we were kind of trying to get into the OECD, so we need to change some of the treaties, and we were on that path. And other ones because we have certain specific rules that give certain tax benefits for Argentinians that the government didn't want to apply, and this was the case for Brazil, as Ramon already mentioned about dividends and also the sale of shares, something that we'll mention before after, and then because of certain specific exemptions. There were two main features about, I would say that, or three, let's say, two in favor and one against. The first one is there was an exemption for the sale of investments in Argentina for Argentine taxpayers. So in that sense, we could see, and this is something that happened with Brazil and also with Austria, with the two treaties, where there was an exemption, specific exemption there for investments in foreign countries. So we could see companies and we could see individuals investing in shares in Brazil, or investing in bonds, or investing in Austrian bonds just to get the exemption. And there was a tax exemption for services rendered in Brazil. So if you render a service in Brazil, there was a tax exemption, no taxation there. But this last thing also entails a problem, because we have a double taxation problem, which was when I have a service rendered from Argentina, it was taxed in Brazil, and I couldn't use a tax credit because of the exemption rule that the double tax treaty had and the local rules which not allowed to use a tax credit for a local source income. So Argentina taxed or consider a local tax income any service rendered from Argentina. So any withholding performed in Brazil was not or could not be credited for the services in Argentina. So the credit now, double tax, Section 23 of the tax law allows now the credit. Okay, I already passed this. Just a brief comments. There were changes in the dividend section, in the royalty section, and in the interest section. And now instead of allowing, every country to apply its own tax withholding rate, then it's limited. 10%. Talking about dividends, 10%. If the beneficial owner is the owner of 25% of the profits, 15% in other cases. In the case of interest, it's 50% of the gross amounts. And then royalties and all the questions or all the discussions that we do have about the definition of technical services. I would say that in this case, where you have administrative services, including the definition, the question is whether there's room to apply Section 7 in the tax treaty, and to which services, let's say. Okay, then we're talking about exchange of information, about the new treaty, the difference between the old treaty and the new treaty. The new treaty includes the confidentiality of the information, and this is something that it's a key player in every exchange of information, because if confidentiality cannot be ascertained, let's say, countries will not exchange information. The treaty does not include an automatic exchange of information, but I would say it's an on-demand exchange of information. So that's a key driver there. Well, Ramon already talked about the mutual agreement procedures, the MAPs. Here, the problem that we may have in Argentina, it's whether can Argentina allow that a foreign country rules over taxation in Argentina. I think it will be the same problem for Brazil, and how this will apply. Even though we have the treaty, even though we have this rule, the question is whether this could actually be applied and fulfilled, and how. So that it's something that is really interesting to analyze. Then we have if I'm going too fast, just let me know. I can go slower. Then we have, talking about the permanent establishment, Argentina. This is a key element for Argentina, since Argentina did not have a definition of permanent establishment in its own rules. This means that we all, with treaty countries, we went to the definition of permanent establishment, and with non-treaty countries, it was just a broad definition about how we could understood a permanent establishment was. Then I think as of December 2017, this changed. There was a change in the income tax law, and we included a permanent establishment definition, most likely like the OECD model, with some specific changes that were included from the different tax treaties. And this treaty includes a definition of permanent establishment. It's not exactly the same as the definition that we have in the income tax law, and this is important because we could actually use this section in the treaty to circumvent certain aspects of the local tax law. And this is specifically looking into what are the excluded activities in this section that are not included in the permanent establishment law in Argentina. Then there was an LOB clause included. Not exactly an LOB, but it was a base erosion, let's say a BEPS clause. Ramon mentioned something about that, where no treaty benefits will be granted if its main purpose is just a tax matter. This is something that we are used in Argentina, since we have this substance over form rule from many, many years ago. And we have other case law from Supreme Court regarding to, let's say, the corporate structures, not just from a tax matter, but from a corporate matter. So we have those different rules that apply to this kind of rules. So in that sense, what we can see there is that we always, in Argentina, when we apply or when we analyze or when we, let's say, try to get to the best scenario possible, we always need to take into consideration which is the economic reality, the substance of the whole business. We cannot rely on just form. So this section to us, it's not something that we are not used to. It's something common for us. For instance, we were discussing earlier about the logro presumido in Brazil in comparison with Argentina. The minimum presumed income tax it's not similar to that, or was not similar to that. In Argentina, we have to apply transfer pricing. It's something that we need to do, and we always need to have substance. Then going back to what Ramon was saying about this case where Argentina had, or it was discussed in Brazil about what should happen to the benefits that were applied on a treaty in comparison with the change, let's say a treaty shopping, thinking about changing of the country that will apply the withholding. In Argentina, we have a common practice where I think that it was the rule in Brazil, it's similar, whether if you accrue those taxes in a first country, then you need to apply that treaty and then ask from the change in the circumstances, and not only applies to a redomiciliation, but to, let's say, transference of a loan or assignment of a loan, and having two different countries, then we don't have any specific rule about it in Argentina, but then we kind of try to apply that difference. I think I went too fast. I don't know if you'd like to address any specific items, Michelle or Ramon. I think we're actually on time, but then just let me know if.
I have some questions, but I think Michelle can address these questions before.
If you want to make some points before we go to the actual discussion, please go ahead.
My first question would be about, Thomas mentioned that Argentina signed the MLI, so my question is provisionally, but how different is the approach that adopted in the MLI in relation to our protocol?
Well, the thing is that in the MLI you have LOB rules, you have beneficial ownership rules, and you have substance rules. The thing is that, for instance, you have simplified approach, or you have thorough approaches. Let's say, for instance, or complete approaches, for the sake of the argument. So I would say that the question is which is the clause that applies to every country, because if there's not a match, for instance, with the Netherlands, we have no matches there. So then we have no clause. But we do have a double tax treaty that does not establish any of these rules. So in that sense, I think that with Brazil, we have this rule, and this rule applies, and we have no other interpretation in the MLI. And we're not bound by any difference that we have and any change that we have in the MLI. You know what I mean? It's like there's the difference that we are seeing in Argentina is that the MLI limits and may change any structure that we may have in the future. Instead of having a rule in the treaty, only the treaty, which only relates to one rule that you need to analyze when you do an international structure. The thing is that there are similar rules, because the MLI took the definition from BEPS and use it in the MLI. So there are similar rules. The question is how you apply it, and if it's a bilateral definition, let's say, for instance, you need to analyze it and then you go to a map between Brazil and Argentina, whether you need to apply the MLI, and how do you interpret that? So I think that it's a practical matter rather than a technical matter.
The second issue, you mentioned like a distinction between administrative services and technical services, and here in Brazil we have a kind of different distinction because we usually work with technical services versus ordinary services. So, and for me, it's not very clear what are the administrative services from an Argentinian perspective.
It's everything that is not defined. You know what I mean? It's like when we have in Argentina we have registered technical services. It's registrable know-how, and if you can register them, you can apply a reduced income tax withholding rate, specifically established by law. If you cannot register them, then you have to apply 31.5% over the withholding. So that is a key difference. And then you need to go to the definitions of the double tax treaties. So some of the treaties establish that they need to be registered, and they make that difference. So if they're registrable, then you are on the royalty section, and if they are not, you are on section 7. And then you have other tax treaties which are broader and do not establish specifically the obligation to register those services. They start talking about non-registrable know-how, and they start talking about administrative or ordinary services. And then two other things to mention there. The first one is we have a specific law in Argentina. It's actually at this position, it's called in Argentina, which defines which are the registrable services or not. And there are some services that are actually left out. So some financial and commercial services and industrials. They're only targeted to industrial services, let's say, that the registration. But then you have definitions in the tax treaty which specifically include commercial services, for instance. So you have a law in Argentina which says they are not, but then you have a treaty that they say they are. But then you have other treaties which establish that technical services, and how they define technical services, it applies in every tax treaty. And that is the first one. I was thinking about two, but I don't recall the second one.
And just a last question. You mentioned that the administrative practice in Argentina allows tax authorities to disregard transactions when one of the main purpose, you use this expression, the main purpose, and it's somehow different from one of the principal purpose, because main purpose versus one of the main purposes. So the PPT clause changed that from a practical perspective in Argentina, because it seems to me, like as a foreigner, that the standard of the PPT clause is lower than the domestic law practice in Argentina.
Well, that's a good question. I have an example here where if it has 4 legs, a tail, it barks, it's a dog, not a cat. You can say whatever you like, but it's a dog. So the Federal Tax Authority always says, well, if this is a dog, this is a dog. No matter what you say. And this is in comparison, let's say, for the rulings and for the formal clauses we all see in Europe and etc., where you have a law that says that if it's a dog, even though, it's a cat, even though it barks. You know what I mean? So in Argentina, we also have that rule. So it's really, your comment, it goes exactly to the bone, where if I have a lower standard or a higher standard in double tax treaty, I could be able to apply it, even though the standard in Argentina is lower or higher. Then you will have this discussion with the Federal Tax Authority that it will always go to the best scenario they could apply. And the lack of, let's say, of Supreme Court rulings regarding this, it's kind of a problem. Actually, it's not a matter of this lecture, but then recently we have a case law, Molinos, that talked about the double tax treaty with Chile. That's a treaty that has been also renegotiated due to the fact that there was an exemption to the dividends. And then there they ruled that in favor of the Federal Tax Authority, stating that there was let's say, a misuse of the tax treaty. So it's kind of difficult because we have really small, a really small amount of Supreme Court cases.
Thank you, Thomas.
You're welcome.
Thank you, Thomas, Professor Thomas. Thank you, Ramon, for the questions. They are very interesting. I would like to just step back to a broad perspective to ask you how do you feel taxpayers reacting to this renegotiation? Do you feel that it improved investments in Brazil, or taxpayers decide to circumvent this, or in any way from implementing tax plans? How do you feel the markets after the renegotiation from the Brazilian and the Argentinian perspective?
Just a quick comment there, Ramon, if I may. For instance, when we heard the news that the country was renegotiating the treaty, local companies and individuals immediately sold any holdings, investments they had in Brazil. Not everybody could, but the ones that were actually using that exemption did it and changed. It was the same thing that happened with Austria. Sorry, Ramon, go ahead.
No, I think from a Brazilian...
Sorry, Ramon, before that, just to have an in-depth analysis here. So you're saying that the treaty actually disincentivated investments because, as you say, the local companies saw everything.
Yes, they did. Because you had, there's something that changed within the years, I think, and this is a personal comment, and you can actually add up to that. I think that the economic situation of Brazil in the 80s and as of the change of the Delta Tax Treaty changed dramatically. Brazil, it's a brick. It changed the economy, and actually it grew a lot. So there's a difference in the way in which you could see the macroeconomic situation of Argentina and Brazil in the 80s and how you see it today, or in 2018 or 17, where these discussions were held. So in that sense, there were many investments in Argentina and Brazil, and actually using this double tax treaty. And yes, to answer your question, that changed. There are many positions, at least from our clients, that changed. And they sold it, and they went to another jurisdiction where they have a similar or different exemption.
Yeah, I think I agree with Thomas from a Brazilian perspective, because now we have the principal purpose test in the treaty, we have a specific definition on technical services, we have the repeal of the exemption method. So there are a lot of cons, and there are some pros like the taxation of capital, but I think in general, what we have is the adoption of anti-BEPS measures in the treaty. So I think for taxpayers, it's not something that will increase the foreign investments or the relationship between both countries.
Well, that's not good news, but it is what it is. Regarding the prevention of treaty abuse, we heard about of that yesterday in the panel with the representatives of tax authorities, and Ramon said seems to give a lot of importance to the preamble, reading inclusive what that's through tax evasion or avoidance, but we don't know what's tax evasion or avoidance, right? It's different from Argentina that it's used to a substance of a form. Interpretation in Brazil were more formal, let's say, put that in that way, and have even legal procedures like the ADI 2446 when we discussed or supposedly or allegedly anti-avoidance rule. So I'd like to understand, Ramon, if you think that the preamble has normative force enough to prevent the abuse of the anti-avoidance application rule.
No, I think the preamble always has a limited effect because it cannot override other treaty provisions, and it will not prevent the application of the treaty when you don't have a specific provision dealing with that issue. So in my opinion, the preamble only shed light on the interpretation of the treaty provisions that we have. So it can shed light in the interpretation of the PPT clause, because we can use the preamble and the PPT clause to actually understand what the countries intend when they included the PPT clause in the treaty. You can use that to interpret the treaty provision in relation to triangular PE cases, or when we have cases involving like commissionary arrangements, or eventually cases with a splitting up of contracts and provisions that were not adopted in the treaty, but somehow may be countered with the PPT clause and the preamble. And so I think it's a limited effect. So I don't think the preamble can solve all the problems in the absence of specific provisions in the treaty.
Well, thank you, Ramon. It's again, there is no correct answer here, right? It's just what you have from the practice. And I have another question now regarding the application of the taxation of technical service. It's a main issue here in Brazil. And now we have in the Argentina-Brazil protocol the definition what the technical service are. But we have other treaties, new treaties even, that we have the addition of Article 12A. So I'm not sure how we apply Article 12 and 12A in this perspective. And I'm also a little concerned about the possibility of parallel interpretation, as the other treaties does not have a similar provision. So I'd like to listen to you if you have the same questions in this regarding this issue.
Michelle, if I may add, I have an additional question to that is, what else is there for services not included in this broad definition? So it does cover everything? You know, you mentioned, Ramon, about ordinary service and technical services, but it seems that and this is a question, it seems that the definition of technical services in the treaty includes ordinary services, isn't it? Or at least it could be construed that it includes them. So did the treaty intended to cover every service? Or there are services, this is a question also that we ask ourselves in Argentina, whether there are services not included by the treaty. It's really difficult to pinpoint though that.
Yeah, we have a similar debate here under our domestic law, but considering the definition, and the definition of technical services is very broad, because it basically encompasses all services that depend on specialized knowledge, skill, or expertise. So it's really very broad. Based on our case law, there are just a few examples of services that were considered ordinary by the tax authorities, like commercial representation and insertion of advertising in TV channels that were considered ordinary services, and then the corresponding remuneration could fall under Article 7 of the treaty. But all other cases analyzed by our case law were considered technical services under Article 12 by the tax administration, and then we have that debate before the judicial courts that I mentioned. But for instance, human resources, legal advisory, logistics, IT, engineer, maintenance, and all those services were considered technical, but by the tax authorities. So it's somehow a kind of gray area, because I think it's not it's difficult to set a clear distinction between ordinary services versus technical services, because all types of services somehow depend on knowledge or technical knowledge. So I think this definition is not very precise and clear, but we have somehow some decisions that considered, as I mentioned, certain activities like commercial representation as ordinary services. But you were right, and I don't think in relation to Article 12A, I think there are some. I don't think there is a real difference in relation to the scope between Article 12A and this new definition included in the treaty with Argentina. But what may happen is that in treaties where we have the 12A, we usually change the approach in relation to Article 14 that deals with professional, independent professional activities. So this may lead to a difference in practice, because in the new treaties, we start to include the fixed base rule in Article 14, and in the old treaties, we didn't have that. So you have cumulative taxation in Article 14, regardless of fixed base, and we have a specific definition of royalties of technical services to include such remuneration in Article 12.
Thank you, Ramon. Yesterday, we heard from one of the speakers that it was never the intention of the tax treaty negotiator to narrow the concept of the technical service to associating it to the transfer of technology. I don't know if I agree with that, but again, when the treaty is signed, the intention is not, it's like the law is not really relevant. So what mattered is how it was put on the system, right?
Yeah, and there, just to add up, you have the difference between how the treaty defined royalties beforehand and how it's now defined. So changing this scientific, industrial, commercial know-how to even administrative assistance, it's like, well, you're making a statement there. So then it's difficult to circumvent that definition, or at least to apply it. Of course, we agree with Ramon about Section 14, but then it's difficult to apply to the, let's say, management fees that are commonly used or fairly used in Europe and in the US.
I think each tax treaty is unique, so it's very difficult to say, like in general terms, that it was not the intention of the contracting states. I think in some cases I agree that it was not the intention, but as Michel mentioned, intention has a limited effect into the interpretation if we consider the rules set forth by the Vienna Convention on the interpretation of the treaties. And so I think it's except when you have elements that can be used as supplementary means of interpretation, I think it's very difficult to argue that the intention to reduce or to expand the scope of the treaty.
Well, actually, Ramon, Argentina is not part of the OECD, but there are case laws stating that you could use the comments of the model to interpret the treaties. So even though we're not part of the OECD, so it's not specifically in intention, but then what you include in those comments, you know.
Well, now we have 2 minutes to finish the panel, so I would like to thank you again, and I would like to grant you 1 minute each for your final remarks before finishing the panel. I would like to pass the floor first to Professor Thomas to give his final remarks.
I will say that I have only one specific remark, is whether this tax treaty will allow Argentina and Brazil to grow economically, in the sense that we are brother countries, just for the matter of, for the sake of the argument, and then we need to use maps, we need to have this back and forth relationship between both countries in order to be able to grow. And thank you very much for the audience.
Thank you, Thomas.
I just would like to thank for the opportunity and for the discussion here. And I agree with Thomas. I think it would be good to see more frequent use of the mutual agreement procedure. I think if there is something good in the new protocol, is the opportunity to start the map cases in both contracting states, because sometimes taxpayers have a not very enhanced relationship with the tax authorities. So when you have the opportunity to start the map case before the tax administration of the other country, sometimes it's easier to start the debate on those issues. So I think this can improve the relationship between both countries. Thank you, Michel.
Thank you, Ramon. Thank you again, Professor Thomas. Thank you both of you for accepting the invitation to be here, sharing your practice and your background with us. And now, just in time, I would like to invite Professor Felipe Valada, who will host the next panel, when we will discuss a little bit on the application of the tax treaty between Brazil and Uruguay. Felipe, welcome.
Hello, Michel. Thank you very much. It's a pleasure to be here. Thank you for the great discussion. Thank you, Ramon. Thank you, Thomas. So it's a pleasure to be here hosting the second panel. I don't need if we need a few minutes to put everybody of the next panel
we'll have
in there.
Philip, we'll have a 10 minutes break now. So the next panel will start 9:50. So
perfect.
We'll leave the floor for you and then the next speakers. Thank you.
Thank you. Bye-bye.
Thank you. Bye.
Welcome, Fabian.
Hi, Felipe. How are you?
Very good. Thank you. A bit cold, a little bit of lockdown, but managing.
It's true, too. You are in Austria. Well, here it's, fortunately, we are in a different situation, but we also wish that all this COVID situation will end soon.
Let me just check something. Bon, Fabian, I think we're just waiting for the other speaker to join.
Cool.
And I think that we should start our discussion. I think we had a very interesting talk before us. And yeah, I'm happy that we managed to discuss a little bit more of Latin America and South America now, because in the next upcoming days, we'll talk a little bit about how the economic relationship due to treaties will develop with Europe and I don't know, Switzerland, not really Europe, but with the EEA.
For sure. I think that Uruguay will look quite interesting from the point of view of the tax treaty, how the country deal with this situation, and how what is our vision about the tax treaty, and what's going on in the current world. So I think that it could be interesting, not because of Uruguay as a country, because it's a small country, as an example, and how a developing country might face the international tax arena, including the tax treaty. So I hope it could be interesting in that point of view.
No, absolutely. With this series, I think we're able to compare later. And it's something that in the end, we don't really take that much into account, which is we always, as tax practitioners, we always criticize why this has been done in such a way. This is not so logical. It would be better for the country if this provision was or was not there. But we forget that it's a struggle of powers as well. And
yeah, for sure. I do remember when I studied abroad, I did my LLM at LSE, that the first paper I had to read was about, the author was Chili Dagan, and the title was The Tax Treaty Myth. And I was shocked, because the first time I read, tax treaty is not about double taxation. It's about how to allocate power between countries. And then I realized everything about Uruguay. It's a small country, and I will explain later. Uruguay is not worried about double taxation in a source country.
Yeah.
And there is no capital export. So there is no problem about double taxation in Uruguay. Nothing to do.
There's a study of, I think it's from the Netherlands, the paper, and they discuss whether it's in the interest of developing nations to sign double tax treaties or not. And it's funny because it's funded by the government, this research, and the outcome, it questions a bit whether it's interesting for the developing countries to sign it, if it's not more relevant in the end to give security and tax breaks to these developed countries.
Yeah. It's.
I believe good morning to infatuating to start.
I'm listening to.
Paulo, o seu áudio acho que está com um pouco de delay aí, meio robotizado. Você está ouvindo a gente bem?
Eu estou ouvindo você. Não,
I hear you as a robot.
Tudo bem? Não.
Parece ser a internet. Vê se você consegue dar uma reconectada. Eu continuo conversando um pouquinho com o Fabian aqui. Também não. E eu acabei de ter uma dica aqui, uma colinha que o Michel mandou pra gente, que acabou de moderar a sessão. Sorry. I just received a small hint from Michel, who just moderated last session, that Professor Sérgio André also has an interesting article on the topic. And I think it's interesting because it breaks when we were students. As you said, we grew up with this repeated idea that is always interesting and is always going to enhance relationships, and it's good for us to question a bit things, how it's done.
For sure. I believe that the OECD, the best part of the OECD, or one of the best parts of the OECD is the marketing department of them.
For
they
sure.
make believe everybody that tax treaties will save the world. And this is not true. At least this is not true for developing countries such as Uruguay, a small country that rely on foreign direct investment. This is not the case. I will try to explain during my presentation how is the tax treaty, tax system structure, what was the situation of the international taxation, and how we are facing right now the international tax cooperation. It's in a general way, because tax treaties were part of it.
Yeah. So Paulo, can you hear us now?
Now, can you hear me?
Very good.
Okay,
Perfect.
okay. I left and now I am back. Now only to say hello to you and good morning, Fabian. Until we start our second panel and waiting for Romero to enter also. And this is a very exciting event. We started yesterday here, receiving as guests and speakers the representatives of the federal revenue in Brazil, bringing their perspective from the tax authorities about the new treaties. And as you in Uruguay, we also are facing this new world, this new tax world, these new measures regarding taxation. And I would not say we are suffering because we are not seeing only negative points. On the opposite, we are also seeing very positive points. Yesterday, we were discussing about MAP. This is something very positive for taxpayers, although in my view, in practical terms, we need to improve a lot. Things that we see in paper that would be great for taxpayers at the end, in practical terms, not because of the tax revenue, but because of our internal legislation. We have a lot of impacts in applying this, but anyway, we need to see the whole picture, and we see also very positive points by this new area. And Uruguay, for sure, is a very important country to Brazil. Yeah, not only because we are neighbors, but of course because Brazil and Uruguay have a long and tight relationship, business relationship, and Uruguay is also a great platform for investments, right?
Yeah, for sure.
And a great entering, a great open door to Latin America is Uruguay.
For sure. I don't know what happened with Felipe, I think.
Yeah, no, we are just reconnecting here, waiting for Romero, because this panel will begin in 2 minutes.
Okay, fair enough. Yeah, for sure. I think that Uruguayan situation could be interesting for Brazil to show how irrelevant are tax treaties for countries like Uruguay. At least irrelevant for the national purpose. It's relevant to be part of the international tax standards, but not as a part of a strategy that the government is looking for treaties, because it's not an issue, the double taxation for us.
Yeah, for sure. And actually, Brazil and our domestic legislation, we have so tight rules regarding international taxation that sometimes the double tax treaty actually should have a different name, because at the end of the day, the double tax part of the double tax treaty comes in a secondary place. And nowadays, in the past was not this way, but nowadays the other kind of measures that double tax treaty brings in its tax is much more important to a bilateral relationship than actually to avoid double taxation, right?
We had some technical issues, but Romero should be online in any second now, Paulo.
Great.
Prepare the last coffee sips, fix your hair.
Sure. And before I was blocked to speak, I was hearing Fabian speaking about the importance of a double tax conventions, and I read once
from a professor in Munich. Why do we need double tax conventions once we have enough domestic rules to avoid double taxation, right? And that's why the other parts of the tax convention is also important, right? Exchange of information, mutual agreement procedures, and from a tax authority's perspective, to avoid frauds and abuse and other points.
Yeah, I think the matter of uniformization is very important when it comes to tax treaties. I think they are not...
And legal certainty.
Exactly,
yeah.
You cannot solve everything that I think it's been argued to solve in 20 years ago or more. But I think they do play a role. I think it's important for us to try to have this academic distance to understand really what is the role and how it can be used as a tool.
And to avoid ups and downs and uncertainty of the domestic legislations we have, and we face it here in Brazil all the time. In Brazil, I don't know if you know this, Fabian, but there is a research pointing out that every hour, 2 new rules, tax rules, are issued in Brazil. Every hour, 2 new. So to follow this is really difficult.
Yeah.
So that's also an importance of the tax conventions to give legal certainty to the investors in such
for sure. I believe that democracy, macroeconomic stability, a good judiciary system that are far more important than tax treaty. So we are focusing wrong. We should focus on democratics, on judiciary independence, on stability in the democratic. This is what investors should look, and the society itself. So tax treaties is good. It might help in the avoidance of double taxation, but this is not. It should not be the high priority. At least this is my opinion.
Yeah, great.
Now, good. Since we are already 5 minutes since our official start. Oh, there we go. Welcome.
Can you hear me okay?
It's perfect.
Great. Great to see everyone. Paulo, Fabian.
Romero, good morning. So I will leave you. This is not my stage. I came here only to say hello and to wish you all a great debate about this newly signed, not very new, but recently signed convention between Uruguay and Brazil. So I wish you all a very successful panel.
Okay, thank you, Paulo.
Thank you.
Good. So I would like to welcome you all to our event. Good morning, South America. Good morning, Brazil. Good morning, Uruguay. Good afternoon, Europe. We're starting another event, another panel organized by the Center of Fiscal Studies, NEF, of the Getúlio Vargas Foundation in São Paulo. And from now until 11 Brazil time, we will discuss the convention Brazil-Uruguay and a little bit of the impacts on the bilateral economic relations between these two countries. This panel is a part of a series of events to discuss the new conventions to avoid international double taxation signed by Brazil or being renegotiated by Brazil, and their effects also from economic perspective. I would like to thank the Center of Fiscal Studies from FGV coordinators, the professors Eurico Santi and Isaías Coelho. And just a small reminder that the statements which are expressed here are individual, and we already mentioned that before, but they do not express the visions of FGV. Okay. So we'll start with Romero Tavares. I'm very happy to have him here. We've shared some time already here in Vienna. He's a partner at PwC. He's a consultant for the National Confederation of Industries in Brazil, as well as to the Ministry of Economy He's a professor at INSPER. He has an MBA from the University of Detroit, Massey, and a PhD here in our very nice University of Economics and Business in Vienna. On the other side, to discuss the Uruguayan perspective on this treaty, we have Professor Fabio Birbaum. He's a partner of FBM Advisory in Montevideo. He has an LLM in LSE and also a Master of Taxes where he teaches also in ORT University. The way this will proceed, we'll have a 25-minute presentation by Professor Romero, followed by a 25 presentation by Professor Fabian. We will have some time at the end to discuss some points that need more discussion in depth, or even to react to some of the questions that the audience can engage with us. So you'll find below a link for Slido, and you can submit the questions to us, and at the end of the presentation we can try to address this. Sometimes there's more or less time. Let's see how this goes. So without any more delays, please, Romero, the floor is yours. Thank you.
Thank you, Felipe. Thank you, Fabian. Thanks to the Getúlio Vargas Foundation and NEF for organizing and for putting this great event together. The way that I see the importance of this event is also historical. I do think that we're at a point that Brazil is at a crossroads. We've had different moments in Brazil's international tax policy, different moments in how Brazil viewed tax treaties, and this is one of those pivotal moments where we see perhaps an evolution happening. That's my hope. But we definitely see a change. We see something that is not just post-BEPS, but current BEPS 2.0 and Brazil acceding to the OECD ready, a new stage has been set up for the new negotiations that Brazil has been doing. The very fact that Brazil didn't sign into the MLI after BEPS makes this event, but this topic of discussion, even more relevant. Brazil, as everybody knows, and as it is the point of this event, has been renegotiating one by one the treaties that it already had. And it has been adopting this new approach, this post-BEPS and post-BEPS 2.0 approach to negotiating new treaties, or to try to salvage old treaties that it had in the past and it needs to put back in place again, like the one with Germany. So the way that I see it is actually very fortunate. We've had a problem with consistency if we go back a number of years. We've had different moments in time where there was a stop, there was a go, and there was a stop in the drive that Brazil had to actually negotiate and put treaties in place. We've also had a moment where regionalization, regional integration, Mercosur, and economic coherence within the Southern Cone was a priority for all of Brazil's foreign policy, economic policy, and at other points in time, it was not. So I think we have to look at both angles. First of all, how Brazil is viewing international tax and international treaties, how Brazil views its regional trade and regional investment policy, and considering Uruguay as a pivotal partner, as a main partner, a key partner in that regional policy, which never happens from one day to the other. It always happens over the course of many, many decades, as Europe has also shown us. But then finally, how does it all fit together when we think of treaty abuse, treaty use, and how both things can be reconciled? So when we think about it first, where we came from, Brazil has had moments, as I said, where it was a major influencer in how treaty models were designed in the UN. And it was, in the past, a main adopter in different moments in time, such as when it signed the treaty with Austria, where it was actually closer to what would have been an OECD model convention. So we've had different and inconsistent approaches to how Brazil's treaties should look like. At one point, very original, very pro-source country, very peculiar, very Brazilian. In other moments in time, closer to the standard, closer to the norm, closest to what perhaps other countries might view as an ordinary international tax treaty that would have been signed between an emerging economy or developing economy and a European country, for example. So that's why we had this legacy of so many treaties that had the tax-sparing clauses and all those different mechanisms that Europe was prolific in doing with its former colonies. And that Brazil, in a way, when it saw itself as a developing economy, not as a powerhouse, it went into negotiations with that framework, with that mindset, with that UN mentality of a developing market that would be receiving, on the receiving end, receiving inward investment, originating in the resident country, which would be a large, developed, rich economy, investing into a poorer one. So Brazil as a capital importer was one moment where most of our older treaties, which are the treaties with most of the OECD member countries, were signed. In very traditional, in a very traditional way, let's say, without a lot of deviation. Then we had a moment, perhaps about 20 years ago, where we had Brazil becoming the exporter of capital and seeking south-to-south treaties to sign. So new economies to invest into and receive investment from, to trade with, and so forth. And there we saw really very unique ways of drafting, very unique ways of regulating, and also very unique ways of interpreting, the treaties that would be signed with different language. So we saw that with a lot of the, let's say, the newer treaties. But then again, it's a very limited network. So we considering not just the size of the Brazilian economy, but the relevance of Brazil to the world economy, doesn't matter if it's an exporter or an importer, we do not have an adequate coverage of tax treaties or investment treaties for that matter. It's very limited. And in between those 2 points, we had the 90s, of course, where there was the big drive that Brazil had was regionalization, regional integration, partnering up with Argentina and Uruguay and Paraguay, and energy on the one hand, trade on the other hand, agriculture on the other hand, manufacturing on the so there was a lot of interesting and somewhat coherent, consistent policies for the 4 key countries to develop together, taking advantage of complementary, let's say, pros and complementary competitive advantages vis-a-vis the rest of the world. And in this sense, Uruguay has always been a stable, developed financial hub, financial market on the one hand. On the other hand, it's always had this vocation to function as a hub, as an intermediary trade hub. It functioned like that in the mouth of Rio de la Plata. I think Fabian will give us an overview also of the economy and the tax system as a whole. But the point is that Uruguay is like Holland in a way. It's the Holland of South America. It can serve as an intermediary trading hub. It can serve as a logistics hub. It can serve as a financial services hub. So it can serve as a facilitator for intra-regional trade, intra-regional investment, and investment and trade between the region and the rest of the world. Considering the instability of Brazil and Argentina, given their size, their legacy of poverty, and so forth from an economic point of view, Uruguay is somewhat of a safe harbor within the region that could serve as an advantage for the region to trade with the rest of the world. So when we think about it from that angle, the 90s had this appreciation for Uruguay, and had this appreciation for the region being a region, for Brazil being a key country, perhaps a leading economy within the region, right? And again, 2000s, that shifted to Brazil being more concerned about Africa and Asia and China and India and south to south, but not necessarily regional. So if we think about it geopolitically, and if we think about in terms of how that influences the treaty policy, it's visible. So we can see it. First, Brazil as a receiving country, then Brazil as a regional, part of a regional bloc, then Brazil as a capital exporter going into Africa. So there's footprints of those 3 different moments in how Brazil's tax treaty policy has been designed, and even in how treaties have been interpreted and applied by the authorities. So when we pause and we think about that with that historical lenses, and then we see what happened in the last few years, it really poses some very interesting questions for how Brazil and Uruguay will move forward in their economic relationship. So how, from a tax perspective, will Brazil view Uruguay? Will Brazil respect Uruguay as an intermediary hub, as a facilitator, as a triangular jurisdiction that helps capture foreign investment into the region, that helps facilitate trade with the region? Or will Brazil take, which in my view is what tax treaties are for? I'm going to start being a bit more, let's say, spicy here. But I do think that the tax treaties are designed to be bilateral. They're not designed to be treaties with the world. So to the extent that we have a treaty that is post-BEPS and that is rich in anti-abuse provisions, it will also be strict in terms of anti-triangulation type provisions, in terms of limitations on benefits and limitations to treaty entitlement, which is, again, where perhaps the role of an intermediary jurisdictions like Holland in Europe, or Switzerland, or like Singapore, or like Uruguay, which is our own version of those other three, fits within the bilateral treaty logic. So with that lenses, we do come to where we are now. And where we are now is, again, Brazil is not just with this newly signed treaty with Uruguay, but with the treaties that Brazil has been renegotiating and signing again. Brazil is in a moment where it is adopting not just the, let's say, the common denominator that we see in a lot of the MLI provisions, but it's going a little bit above and beyond what went into the MLI, but what actually was part of the whole logic, the whole reason, the whole object and purpose of the BEPS recommendations, not just the standards, the minimum standards, but the recommendations. And in that sense, what I see is that all of the treaties come with slightly different language around the anti-abuse provisions, limiting treaty entitlement in a Brazilian way. So our LOB clauses are not the standard LOB clauses. It might be closer to the origin. They might be closer to the original intent of when those provisions were designed by the Americans in the US treaty model, which is, again, is viewing the world in a very flat way, viewing the world as a bilateral world, not really embarking on a view that intermediary hubs are good things to have from a coherence of the investment and tax system point of view. So if we are, if you will, influenced by that historical view of how limitation on benefit clauses should be applied, and if we're using very specific language, which is not the same language that is being defended as a minimum standard post-BEPS, but it's something crafted specifically designed for the bilateral treaties we're negotiating, we can certainly expect that, and I do believe quite rightly so, Brazil will be very strict in recognizing treaty entitlement in situations where the residence country investing into Brazil, ultimately the ultimate beneficiary from considering the whole corporate chain or capital investment chain, is not Uruguay. So from that perspective, when we have an Uruguay originating investment into Brazil, Uruguayan capital, which is not a lot of companies, it's not a lot of, it's mostly the economy there is an intermediary hub. I mean, it's a platform for investment to flourish, within the region and elsewhere. So if we have capital originating in Uruguay, flowing into Brazil, no doubt about treaty entitlement, not even going into the intricacies and the details of whether or not it's a publicly traded company, listed company controlled by residents, but even the activity-based test, so the bona fide test that is embedded in the LOB clause, and even broader than that, the principal purpose test, the treaty title, the treaty preamble. I mean, how much will Brazil see in the treaty an avenue to capture foreign investment which does not originate in the immediate treaty partner jurisdiction? If there is substance, if there is a bona fide, a trail of evidence and facts would Brazil, grant treaty entitlement, recognize treaty entitlement to an Uruguayan company that is not ultimately controlled in Uruguay, that has some activity in Uruguay, that has substance in Uruguay, but really that serves an important purpose of also allowing the application of a treaty rate to a jurisdiction that would not otherwise have it, because again, Brazil's treaty network is quite limited. Again, it will be challenging from my perspective. It is something that the way that I see Brazil designing its policy, it is not designing its policy to have just a few treaties that would be treaties with the rest of the world. It's designing its policy to have bilateral treaties applied bilaterally, the way that treaties were originally designed to be, and therefore it would probably be quite challenging to acknowledge entitlement to the treaty for an Uruguayan entity that serves an intermediary role, either for trade or investment or funding or what have you. So this is, to me, when I think about this treaty, this is to me the first point and a key point that we have to think about and think through. Because again, it's an innovation. The way Brazil is designing its LOB and the way Brazil will start to interpret the PPT and the treaty title and the treaty preamble will all be uncharted waters. We will be venturing into uncharted waters, knowing that the framework and the mindset is it should be bilateral. It should be dealing with, let's say, non-tax motivated investment flows and trade flows that should not be unduly harmed by double taxation. The logic is a bit different from what it has been in the past, be it when Brazil viewed itself as a capital importer only, be it when Brazil viewed itself as a capital exporter to Africa. The logic now is different. It's not just a logic to facilitate flows and to facilitate investments, but it's also a logic to curb not just abuse, but avoidance. So to curb what might be viewed as aggressive planning or not aggressive planning, but to curb planning, to curb a tax motivation being an important part of a capital structure or a trade structure or an investment structure. So from this perspective, the treaty with Uruguay, to me, becomes very sensitive. Because again, is it in conflict then? Will the tax policy now be in conflict with Brazil's trade policy? Have we walked out of Mercosur? Do we think that Uruguay is a tax haven? Do we think that trade, if it happens triangularly, involving, not just the region, but outside of the region, but to the benefit of the region as a whole, and to the benefit of Uruguay as a key partner within the region, will we discriminate against Uruguay? In my view, it doesn't make sense. We have to find a balance there. So even if we do have as a general rule for international tax policy, this, let's say, more limited or more strict approach to entitlement, when we think about our Mercosur partners, I do think that the bar is a bit different. So how strategic the bona fide activity is to the trading partner. For instance, Uruguay is a financial market, a financial center, and it's a free trade zone center, and it has its own economic policies which are designed for it to function and to survive as a small open economy. Brazil is not a small open economy. Brazil is a large closed economy. So if we want to respect Uruguay as a Mercosur partner, if we want to respect the commitments we've had, we have been defending for years within the, let's say, the mechanisms that have been built under Mercosur, we should acknowledge that Uruguay is our Switzerland and is our Holland and is our Singapore. Therefore, it will serve as an entreposto, as an intermediary hub for trade and for investment. So as long as that's not abusive, as long as that's not artificial, I do think that it's not a matter of treaty abuse if we do have third country capital flowing into Uruguay, out of Uruguay, third country trade benefiting part of the supply chain, including Uruguay and so forth, irrespective of whether Uruguay applies a high effective tax rate, a low effective tax rate, whether Uruguay excludes foreign income from its base or not, if it's a territorial residual. Again, it's within the sovereignty of Uruguay to decide how to tax Uruguayan income. So to the extent Uruguay decides to apply its own system in a way that differs from Brazil, that makes Uruguay more attractive, to be honest, to foreign direct investment, and to the extent that is used by foreign investors in a way that allows for the region to trade, that allows for Mercosur to function and to fulfill its object and purpose, why should the tax policy differ and punish in a way or discriminate against Uruguay? It will be very interesting to see how that plays out. But I think that is the challenge ahead of us. Will we understand that Uruguay is sovereign enough to be a more investor-friendly and trade-friendly tax jurisdiction, and at the same time be substantive enough to still benefit from that tax friendliness and still be entitled to the benefits of the treaty with Brazil? I think it should. But I do think that is the challenge that is ahead of us. That is the new uncharted waters we're starting to venture into. It's basically to see how will we reconcile the role of Uruguay as a regional hub within Mercosur for investment, for capital and trade, the role of Uruguay as a safer jurisdiction to attract third country capital into Mercosur, much in the same way that Europe has it with the Netherlands and a few other countries there. Third non-European, non-EU, non-EEA capital flows into Europe many times through those jurisdictions and then benefits the region as a whole. So can we see Uruguay from that perspective? If we can, that the new treaty is compatible, even if interpreted with a lot of strictness, but it's compatible with the object and purpose of Mercosur. If we say no, I mean, Uruguay will not be entitled to have its own tax system, to have free trade zones, or to have the territorial system and to apply its own fictions that Fabian will explain to us on what is income from Uruguay, what is not. So Uruguay is not entitled to its own tax system, to its own tax sovereignty, which results in a lower effective tax rate. Uruguay is not entitled to its own economic policy that results in it being a more stable jurisdiction for inward investment from OECD countries than Brazil. Uruguay is not entitled to all of that because it results in a tax discrepancy if the treaty is applied. If Brazil takes that route, to me, it will be a route that collides with the object and purpose of Mercosur. It might even collide with the object and purpose of the treaty, because we know what Uruguay is when we signed the treaty with Uruguay. We know how the Uruguayan economy works before we decided to have a tax treaty with Uruguay. So it wouldn't make sense to me to limit the benefits of the treaty only to capital that originates from within Uruguay. Again, we have to be, I think, careful, but that's the challenge that is ahead of us from my perspective. So I think with that, I'll pass the floor to Fabian, and he can give us a perspective on the Uruguayan side.
Romero, thank you very much for your comments. I think it was a brilliant overview of the policy that Brazil has had and where it's going. I think it complements the discussion we had yesterday, where we were able to see the perspective of the tax authorities that made an exhibition yesterday. I think that is main discussion that we have, and sometimes we miss sovereignty. This is a key point now. It's a key point when you negotiate a treaty and when you negotiate the clauses, because in the end, whether it's a smaller country or a medium-sized country or a developing country, very often there's limits to what one can push for. And yes, that's a brilliant point. And to develop on this and other matters, Fabian, the floor is yours. Thank you.
Thank you very much, Felipe, and it was really interesting to listen to all the comments in this panel, and thanks for the invitation. I would like to introduce the Uruguayan example to show what is the situation of a small developing country. At the end of the day, most of the world depends on small developing countries. There are few developed countries, and I will try to show which is the situation. and how the country faced all the international tax arena, including the tax treaties. I don't want to spoil the end of this presentation, but Uruguay is not so interested in double taxation because it's a source country. We are, and the Uruguayan do not export capital to Brazil and to the rest of the world. We are a typical capital importer country. So a source country with a capital importing country means that we are not worried about double taxation. Therefore, we do not need international exchange of information. So the question is, why we are signing this tax treaty? Well, okay, I will try to answer all this during my presentation. I will try to show I will try to explain really, really short, I promise. I will try not to be so boring, the Uruguayan tax system, to show how this tax system faced the international tax arena. Before 2008, there was a change after 2008, and a small presentation to guide on everything. So
hey, Fabian, I think you broke down for a second. Could you just repeat the last 10 seconds? I'm sorry.
I just said that I prepared a presentation to show my speech so everybody can see some of the slides. I asked Vanessa to show it. Okay, thank you very much. Well, first, it's a small advertisement of my firm, but I will pass. So the first issue I will try to explain really, really short, I promise, the taxation in Uruguay. So when people come to the country right now, what they are looking for, first, a strategic location. So the country is a small country next to Brazil and Argentina, the biggest country in Latin America. That's why the comparison with Netherlands or the Switzerland, it's really common. Second, there is a territorial tax system, so only Uruguayan income is taxable. The third issue is an exchange market is free without limitation. Basically, this is a message for the Argentinians. This is not the case of Argentina. So when they come to Uruguay, they are running away in some cases from Argentina. That's why we always sail the country in that way. There is no limitation of the transfer of profits or Argentina or of capital. This is another message for Argentina. Right now, we have more than 30 tax treaties. So we have a good tax treaty network, and we are compliant with the OECD standards. So this is a picture right now of the country. How is the tax system structure? I wouldn't say that probably it's easier than Brazil. And I'm not saying that it's easy. I'm saying that easier than Brazil. So basically, in general terms, there is an income tax that it's separate between business, individuals, and foreign companies and individuals, VAT, and net worth tax. All of them territorial. So I will explain roughly the system. So again, territorial tax system. So this is the main criteria that applies to all the taxes. The only exemption that I put in red is to interest and dividends earned abroad by Uruguayan individuals. Only individuals, so Uruguayan residents should pay for the interest and dividends abroad. Mainly they are financial investment. But as you can imagine, in a small country, this is a small tax in terms of collection. So territorial tax system, this is the main criteria that applies to all the taxes. So the business income tax, it's again, it's a tax applied to the net income. The tax rate is 25. So when we were first shown as a tax haven, companies, local companies were asking, why are we a tax haven? We pay 25% of our net income. That means tax haven? Are we tax haven? So we had to explain, no, you are not tax haven. The Uruguayan tax system interaction with the rest of the world means that they can interpret that we might be a tax haven. So there was a misconception of that. And there is a accrual method. So this is the basic business income tax. What happened with the territorial? So one of the main issues that many Brazilians come to Uruguay is for the trading. So what is trading? Basically is the sale of goods or services. So when you set up a Uruguayan entity to buy in Brazil or to sell to China, to buy in China and to sell in the US through a Uruguayan entity. So this happened a lot, mainly at the very, very beginning with commodities. Mainly Argentinian ran away to Uruguay to use trading companies to buy from Argentina to sell to the rest of the world due to the reasons I explained in the first slide, to run away from Argentina. So it was quite difficult for the Uruguayan tax authority to measure how much from that income was territorial and how much was outside, because at the end of the day, there was a Uruguayan entity buying meat from Argentina and selling to China. So in that transaction, how much is from Uruguay and should be taxable and how much is from abroad and should not be taxable? It was quite difficult, and there was many discussions. So at the end of the day, there was a resolution that is widely applied and asked by the Brazilian, saying the resolution at the end of the day says that the Uruguayan taxable is the 3% of the difference of the sale price and the purchase price. So only the 3%. And to that basis, you apply the tax rate of 25. So at the end of the day, you have the tax is the gross margin, the 0.75% over the gross margin. So it's a quite low tax, the effective tax rate. And this resolution is widely asked by the Brazilian. And let me just explain something. This is not a special regime. This is just the application of the source principle, of the territorial principle. It's not, many ask, well, I want the trading regime. There is no trading regime. There is a trading interpretation of the territorial principle. So if we might change if something happens to the territorial principle, this resolution might change. Yes. So this is a typical calculation. How is the effective rate? I show, but I don't. Everybody could read it. Let's move to the net worth tax. This is an annual tax. It's levied on the net worth tax in Uruguay, so basically on the assets on Uruguay. So if you use a Uruguayan entity that holds shares or financial instruments abroad, you won't pay this tax. The rate is quite high. It's 1.5%, only applicable to Uruguayan assets, but this is a high rate to the assets. And for the determination of the net worth, there are deductible liabilities that you might deduct. The VAT is the same. The tax rate of the VAT is 22%. VAT in Uruguay represents 60% of the total tax collection. So you can imagine which is the importance of VAT. At the end of the day, there are few big companies in Uruguay that represent a lot of business income tax collection. What there is there are a lot of people that they consume, they purchase goods and services, and they pay 22% of VAT. That's why the VAT represents 60% of the tax collection. So with this, you can imagine that a country that has source principle that do not export capital to the rest of the world, and the 60% of the tax collection relies on VAT, is not too much interested in tax treaties. They won't be so relevant at the end of the day. And finally, there is a non-resident income tax. This is quite new. It started in 2007. It's levied on Uruguayan source when non-residents come to Uruguay, except for technical services and advertisement from abroad to Uruguay. So when a Brazilian company might provide technical services or advertisement to Uruguayan companies, it might be subject to the 12% general rate. Okay? So this is the picture of the Uruguayan tax system. So I needed to explain this in order to show how important is tax treaty to a country like this? So another importance is the free trade zone. Basically, there are specific places within Uruguay that they can trade, provide services, or sell goods without any taxation. So the users are 100% exempt from corporate income tax, wealth tax, import and export taxes, VAT. So there are like 14 free trade zones in Uruguay, in Montevideo, and in the rest of the country, that from there you can export without any taxation. So what is the rationale behind that? Basically is to try to attract, through the exemptions, companies in order them to hire Uruguayan people. This is why one of the requirements to be allowed to operate within a free trade zone is to have certain amount of Uruguayan employees. So there is, as we say, there is no free meal. What about the anti-avoidance rule? There is no GAR, General Anti-Avoidance Rule, in Uruguay. There is Article 6 of the tax code that indicates that the substance over form principle. But this is not a GAR. This is an interpretation rule. So this is quite discussed within the country, whether this is a GAR that sometimes the tax authority uses as a GAR, but this is an interpretation rule. There are specific SARs, specific anti-avoidance rules, that the basics is to protect the Uruguayan tax base. So as I explained before, all these SARs are to try to protect the tax base, and the tax base is focused on the Uruguayan income. Therefore, there is no SAR connected to international issues, or there are few SARs on that. So I try to explain briefly, I hope not boring, the Uruguayan tax system. So what happened before 2008? Since the 90s up to 2008, Uruguay just signed 2 tax treaties. Don't ask me the reason why there were 2 tax treaties. There should have been 0. I don't have the reasons why we signed a tax treaty with Germany and one with Hungary. You can imagine the total amount of trade between Uruguay and Hungary. It's close to 0. So there were only 2 tax treaties. So before 2008, and totally logical with what I just explained, there was no tax treaty signed. Mainly due to the source principle, not too much interest on tax treaty and exchange of information. And I show here, for example, the exports to Germany. So the exports to Germany were equal before and after the tax treaty. So nothing happened. There was no more exports to Germany due to the tax treaty signed with them. There is, as you can see from the graphic, after 2008 and the prices of the commodities, there were more exports. But this is not because there were more exports, because what we export, the prices of what we export were growing. That's the only reason, after 2008 and the high prices of the commodities. So this is the situation of Uruguay before 2008. What happened after 2008? There was an international crisis, and there were a focus on tax havens and the OECD. And there was, we call here the fever of the tax treaties. I show here how many tax treaties were signed before 2008 and after 2008. And this is a case of Uruguay. And next to this graphic, there is like a picture that was shown in the newspaper, looking at the country running after what we call after the carrot, with the carrot meaning the standard exchange of information, with the OECD saying you have to follow this rule, and the country was running to this. So after 2008, we woke up one day saying, well, you are a tax haven. People were asking why we're a tax haven. We pay 22% of VAT. We pay 25% of our income. Why we are a tax haven? This is not, well, we have to explain that. We have bank secrecy. We have bearer shares. So these kind of features and we have territorial principle, and this kind of features, the interaction of these features with the international tax world might lead to some countries to consider us as tax haven. So the OECD said in that we were in the blacklist, so we have to move to the gray list, and they made us commit to sign 12 treaties. So as a good Latin Americans, we started doing some changes after 2008. So we introduced transfer pricing rules, we eliminate SAFIs. SAFIs, some people that are old here might know SAFIs. There were a special regime for corporations in Uruguay. We started, no, I didn't say it, Romero, you are old. I'm saying that you have a lot of knowledge. So there were exemptions to the bank secrecy. There were introduction of non-resident income tax. There were information of beneficial owners of corporations. So we start doing all our homework to the OECD. Everything this after 2008. We enact anti-money laundering regulations. We signed the automatic exchange of financial information. We amend the free trade zone rules, asking them to have substance on free trade zone. We enact digital economy taxation. So we did our homework. And as I said before, they asked Uruguay at the very beginning to sign 12 treaties. So at the very, very beginning, here in this chart, there are three slides of all the treaties signed by Uruguay. So at the very beginning, they asked 12 treaties, and as a good Latin American, we say, okay, you asked 12 treaties, so we signed with Emirates, we signed with Greenland, we signed with Liechtenstein. So you want 12, you have 12. With really irrelevant countries for Uruguay. I'm not saying that they are irrelevant countries for the trade purposes of Uruguay. So after that, they say, no. They say, stop to be so developing country and sign treaties with relevant countries. That's why when we signed a treaty with Argentina and Brazil, and Brazil was so much interested in that treaty that up to now is not yet ratified and not legalized that treaty. So I can imagine the interest of Brazilian authorities to have the treaty enforced with Uruguay. So, but from 2008 up to now, we have signed more than 35 treaties, you can see here, and with relevant countries, with Italy, UK, Netherlands, etc., etc. Here I put if it's an exchange of information agreement of a typical double tax treaty agreement. So, besides that, we joined the convention on the mutual administrative assistance in tax matters. We entered the automatic exchange on financial information, and we signed the MLI. That I understand that Brazil is not within that. So right now, nobody can say that Uruguay is a tax haven. We say that in the front of the class. So the discussion here at the end of the day is whether we should be at the front of the class or we should be behind the class trying to comply, not too much, but not to be the best student in the class. This is the type of discussions that are happening right now in Uruguay. So in the vast network agreements in Uruguay, there were some anti-avoidance rules, law subject to tax, beneficial owner, etc. But as you can imagine, there are 13 years of experience of tax treaties, and there is no practical cases in Uruguay due to the reasons I just explained. That's why there are few administrative cases in Uruguay related to tax treaty. There is doctrine, but there are few administrative cases. So if you have to say which is the position of the judiciary, I don't know. I might guess, but I don't know. Which is the position of the tax authority of Uruguay with certain elements, we might have no answer to that. So, going to the tax treaty with Brazil, as I explained, my opinion, due to what I explained before, is that Uruguay is not too much interested on this tax treaty, as well as any other tax treaty signed by the country. Some features that I saw in the tax treaty: first, there is service PE. That's something interesting. Also, in the dividends, there is some possibility of limits of 10% if the beneficial owner owns 25% and 15% on the rest of the cases. And in Uruguay, the taxation to dividend is 7%. So as you can see, it's completely irrelevant, the limits, because in Uruguay, taxation is 7%. The same happened with the interest. Limit to source country is 15%, and in Uruguay is 12%, the taxation. So again, completely irrelevant. In the case of royalties, there is a limit to source country with 10%. In Uruguay, the royalty is subject to 12%. Technical services, the limit is 10%, and Uruguay is 12%. So as you can see, with the limits within the tax treaty, it looks like it's not too much relevant. Then there is a tax credit to avoid the double taxation. There is some typical anti-abundance rule when there is a capital gain, when the more than 50% of the value comes from real estate, so the possibility to tax to the other state, that's quite typical. Also, there is a limit of benefits article 29, that establishes a limit of benefit clause in which only qualified persons are entitled to apply the tax treaty. I think that adding what Romero well explained before, that's the main article where both authorities will have to look to understand whether situations with free trade zones or trading companies or substance, or the absence of substance, might lead to the inapplicability of the treaty or not. So from the Uruguayan perspective, there is not too much, I believe there is not too much interest on limiting the benefits of the treaty, because in most of the cases, due to the trade relationship between Uruguay and Brazil, probably Brazil will be the loser in tax collection, not Uruguay, because Brazil invests more in Uruguay than Uruguay in Brazil. So that I believe that Article 29 will be the main focus, and there should be more discussion on that, how it might apply. And I do agree with Romero. When the Brazilian tax authorities signed the tax treaty, they knew about free trade zone, they knew about source principles, so they cannot be surprised afterwards. Regarding the exchange of information, there are three alternatives. Article 28. There is also an exchange of information agreement with Brazil that was not ratified by Brazil, and also there is a convention on mutual administrative assistance in tax matter that was signed with Brazil. So there is like three platforms that may overlap in some cases, and depending of the information needed by one company or the other, it might go through any of these three platforms, which will be how it will be the information exchange. So in order to conclude and to show which is the Uruguayan situation against the tax treaty. So in first place, Uruguayan policy is driven by the compliance to international standards rather than a national interest. As I said before, Uruguay is not worried about double taxation. Why we are signing more than 30 treaties? Because this is part of the international standards, and Uruguay wants to be part of the international world. They want to be compliant with international world. Tax treaty had few impact on the Uruguayan economy. They were signed 35 treaties, and I have, at least my experience and the other professionals that I speak, I've never heard one client that came to Uruguay and saying, I want to go because you have the treaty signed with Hungary. I never receive a Hungarian company. If there is one, please call me. But if they come to Uruguay, they won't come because of the tax treaty. They will come because of the rest of the reasons that Uruguay might have. Stability, democracy, a judiciary that people might rely, a stable economy. Those are the reasons why companies come to Uruguay, not because tax treaties, also because of tax incentives that Uruguay has, but not for tax treaties. Some of the clauses in the treaty are irrelevant or redundant. As I explained before, there are some limits that there is no need to put some limits. From the Uruguayan perspective, Brazil has not yet ratified any of the treaties signed with Uruguay. This looks like, I have the impression that Brazil is not too much worried with the tax treaty with Uruguay, that they have other problems. But this is my impression. And if Brazil wants to foster investment between the countries, probably the tax treaty are not the ideal method to do it. We do have Mercosur from 1995, and the Mercosur is not working so well. The same happens with Argentina. And if we want to be part of a bloc, we should have trade agreement, and that we could sign only one tax agreement between all the countries. This won't happen. But this shows the importance of the trade between the countries. Right now, Uruguay is trying to sign a trade agreement with the rest of the world, and it's asking permission to Argentina and Brazil to allow them to sign trade agreements with China, for example. So this is the focus of Uruguay. Uruguay is not focused on the tax treaty. We are signing the tax treaty because we want to be part of the OECD world, and we want to be compliant and with Brazil. Uruguay do not need Brazilian information of Uruguayan because there is almost no information. Uruguay do not have any problem on the Uruguayan companies in Brazil because there is territorial taxation. So I believe that in order to foster all the Latin American countries, including Uruguay and my country, we should focus more on other issues rather than tax treaties. Tax treaties might help. I'm not saying that they don't help. I'm just saying that Mercosur, democracy, stable economies, a good judiciary system, a reliable judiciary system are more important than tax treaties. So I have the impression that we are focusing more on stuff that they are not so relevant, and probably the main explanation of tax treaties are the allocation of powers between countries and the exchange of information for the bigger countries. This is not the case of Uruguay. So I hope I was clear and I could show the situation of a country like Uruguay. I believe that there are many Uruguays in the rest of the world, and probably we will need to join forces to try to defend the national interests. And again, thanks for the invitation. I hope I was clear, and I'm free to listen any comment or questions.
Fabian, thank you very much. Apparently your camera froze, but we can hear you quite well. So we just continue like that.
Right now?
Yes, but we can hear you loud and clear, so that's okay. Thank you very much. It's interesting to see the perspective of a country that has a different position or a different role or a different role in the international market than Brazil. Brazil is a complex country for other reasons than Uruguay, I think. And just to some thoughts and some comments to the presentation. I saw that the Uruguay, you said that you don't have a specific regime for that. That's a normal regime. And the same thing happened in Austria. We'll see this, I think, more in detail tomorrow. But there were a lot of complaints about the Austrian holding regime, which doesn't exist. There is no such a regime. A GmbH or a limited liability company will be taxed the same way that an industry or if it's a holding company. There are European directives which have some exemption for dividends or straight upstream payments, but that's it. So I think it's important for tax authorities and government to understand the regimes and the specific rules of each country, because in the end Austria was blacklisted or gray listed, and they had to publish a normative instruction. I think it was on the last working day or the second last working day of the year to calm down some of the industry that had investment in Austria. I always thought also that there would be a lot of investment into Germany from Austria, but there's also true that you can also route some investment into Germany via Uruguay, because I think around 2002 there was a small increase, and 2005 a big increase into the trading with Germany, and that's when Brazil and Germany terminated the treaty as well. So I think this was just interesting to point out. A question I would have is whether this placement of transfer pricing rules in Uruguay, if this affected or not the 3% tax base that you mentioned before. And we also have a question from the audience, if being the good student or to being in the front of the class, whether this affected Uruguay as an investment hub. We have, if you have 2 minutes to answer these 2 questions, then I'll move on to the last remarks from Romero, if it's possible.
Do you see me correctly?
Yeah. It's frozen, but we can hear you perfectly.
Okay, so another issue that Uruguay has to improve is the international internet connection. So I'm sorry. So first, yes, transfer pricing applies when there is a trading regime. There should be applicable. But again, any transfer pricing adjustment, it will be only applicable for the 3%. So the impact is still 3%. And regarding, this is a big discussion whether we should be on the front of the class or not. I believe that right now in another conference that I made, I say that Uruguay has less margin to compete and to attract investment through tax incentives. So I believe that the sovereignty, because we were taught by Professor Ramon Valdez Costa that each country is sovereign to do whatever they want. So why Uruguay cannot decide to exempt all the income? We are not part of the OECD. So why OECD comes to Uruguay, they do a peer review, and they say, you are not complying with which rule? We are not part of you. Why? You can say that we are not complying, and you can point out with your finger saying you are the bad student. We are not part of your class. We understand how politics and economics work. What I'm saying is that countries like Uruguay should compete in other fields. They can use tax, but taxes will be I said a weapon that we would be using less and less during the time. We should focus on having stability, having good quality of jobs, having democracy, having all the other features. So I don't know if being in the front of the class it's good or not. I'm just saying that at the end of the day, we should focus on other stuff rather than taxes. This is the reality. I showed during my presentation how many changes the country did. I'm not saying if they are okay or not. What I can assure that all of them came from Paris, not from Montevideo.
Thank you, Fabian. Romero, yes, thank you for the great presentation as well. I think that one of the points that you mentioned time and time again is how to deal with triangular situations, or even how to deal with the hub that we have it inbound or outbound. I think very often we discuss a lot on accepting this or denying treaty benefits, in this case of Uruguay. And I think it's important that we highlight as well that we should be thinking as well, if we don't understand that the benefit should be applicable, how do we move on from this? Because sometimes you're doing things for tax purposes, but very often you have a condition and you have a given set of rules or facts that you have to go and you have to do, and this is what you have. You cannot be that flexible, and it might be that it's a good situation tax-wise. But we have to look forward and see, well, if you think this is not applicable, then why don't we discuss more often? We do have some times, but we have to discuss more often then and look through that and see, well, if the third country is where the beneficial owner or the parent or the capital or UBOs are, why don't we look to that country and discuss the application of a treaty with that country, if there is such a treaty, right? So for you, I have a divination crystal ball question is if you are hopeful with this kind of application or not from the Brazilian perspective, and how do you see the economic relationship with Uruguay moving forward? If you think there will be a difference or impact.
That's a great question, Felipe. And my answer is no, I'm not hopeful that approach that you mentioned would end up being reality. But what I do hope is this. Again, perhaps in some of the countries of Europe that started to place themselves in a tax competition position, like Hungary, for example, we've mentioned Hungary. Hungary is a very competitive tax jurisdiction within Europe, and it wasn't so. It figured out that after the EU that it could use tax as one of the things that could make it more competitive. Of course, after the institutions were in better shape, as Fabian quite rightly pointed out. The case of Uruguay within Mercosur is a bit different. Again, Uruguay has been an entreposto since forever. It has had this role as a financial center, as a warehouse for Argentina, as a foreign exchange, stability, jurisdiction, free translation. I mean, I do remember the SAFIs, and I do remember the time when we had foreign exchange controls in Brazil and Argentina that were horrible, and we didn't have those horrible controls in Uruguay. So one of the business reasons to have a hub in Uruguay was actually hedging. It was not tax, it was hedging. It was easier, safer to have money within the region in Uruguay than it was to have it in Brazil and Argentina. So once the trade was freer, once we started to have goods moving around and even people being able to move around more easily, it did make sense to have treasury centers in Montevideo, good quality jobs for the Uruguayans, benefiting from the stability of the Uruguayan institutions and judiciary and economy and so forth. So that has been known since forever. So when Brazil decided to sign a tax treaty with Uruguay, even with Article 29, even with the treaty title, even with the treaty preamble, it does, in my view, have enough language in there to really be a treaty that would only not be applicable to artificial triangular situations. Meaning that Uruguay has a vocation to serve as a wedge in the triangle that enables and facilitates more trade and more capital flow into Mercosur. It serves as that wedge to plug the holes where Brazil and Argentina have institutional issues or foreign exchange issues or whatever. Uruguay comes in and fits that gap that the institutions or the economy or the judiciary in the 2-3 other countries have, so that the region as a whole can benefit. Not too different from what the Netherlands has done. Very different from Hungary, but not too different from the Netherlands. So again, what I see is that if you look at even the principal purpose test, I think it's in item 9 of the Article 29. Article 29 looks like it's just an LOB clause. It's not. It's a long one, very tricky one, very complicated one. But in the very end, it does have a principal purpose test. But in the principal purpose test, even though it says one of the main purposes is tax, maybe it could be. Maybe I'm using the Uruguayan territorial regime and free trade zone and 3%, and even with transfer pricing, even with Uruguay singing in the front of the class, it will still be a friendlier tax jurisdiction than Brazil and Argentina. So if we have the institutions, if we have the hedging, if we have the foreign currency, and if we have the tax system playing in favor of Uruguay, and that has been there since forever, and that is one of the main reasons for some part of the activities to be there. At the same time, that cannot be inconsistent with the purpose of the treaty, because through the treaty, you regulate how the countries will tax, will view, will exchange information, will cooperate, will settle disputes, will enforce transfer pricing. So again, I do not see it in conflict with the object and purpose of the treaty. So in item 9 of Article 29, you have a PPT that says, yeah, you can override the treaty if that situation, that artificial situation, is against the object and purpose of the treaty. In this case, I don't think it is, because again, Uruguay has been what Uruguay has been since forever. So I do think that will be very interesting. And just one final remark before I give the word back to you, Felipe, and to Fabian, is this, that I do think that that Uruguay should learn from the experience of these countries that noticed that even though, of course, the institutions and the education and so forth are the main drivers, yes, but the tax system within Mercosur, there's no shame in acknowledging that it is part of the country's sovereign economic policy to attract third country capital with substance, without artificiality, without abuse, that benefits the region, that actually enables investment and trade to happen within the region where maybe it wouldn't happen given the tax differential. So from that perspective, in the mutual agreement procedures of the future, in the joint audits, maybe exchanging information, being proactive in exchanging information, but why to defend that an Uruguayan entity is entitled to the treaty, to helping demonstrate that the Dutch do this exceedingly well, superbly well. The Lux also does this very well. So basically, if you acknowledge your role as a positive one, as a bona fide role, as a facilitator of trade within Mercosur, facilitator of investment within Mercosur, then the tax authority, still sitting in front of the class, can be more international, more cooperative to defend the foreign trade, the free trade zone, to defend the substance of bona fide activity in Uruguay that meets the LOB clause. So I think that change in administration policy, administrative policy, it's not the design of the rule. It's administrative policy. If the tax authority can remain extremely strict, the Swiss are very strict. The Swiss authority is not easy. The Swiss tax system is not easy. But they acknowledge their role as a hub also. And once they're convinced that something is bona fide, has good faith, it has substance, they will fight for that entity, for the treaty entitlement to that entity. So I think if Uruguay can reconcile its position with that, so tax is one of the things, it's important. So let's be sure that people are not abusing Uruguay to abuse Brazil. But if it's good enough, the authority in Uruguay should have an uphill battle, but should fight for treaty entitlement, because Brazil will probably fight against.
Yeah, for sure. I do agree, and I appreciate. Our fear is that then the Brazilian authorities will say, well, infelizmente.
Me parte o coração.
Breaks my heart, yeah. Fabian and Romero, thank you very much. This has been a pleasure. I cannot thank you enough for being here with us. I would like to thank Fundação Getúlio Vargas as well. And yes, we will be here, not myself, not Romero, not Fabian, but the series will continue tomorrow and the day after tomorrow with the treaties with Brazil and Switzerland, Austria, and then with Singapore. Thank you very much and have a nice day, everybody. Thank you.
Thank you. Bye-bye.
Thank you.